This is the In Focus podcast from The Hindu.
Hello and welcome to another episode of the Hindus in Focus podcast. I'm Zubaida Hamid, your host for today. There were two recent court proceedings in the country that related to divorce and maintenance. In July, the Supreme Court once again upheld a divorced Muslim woman's right to claim maintenance under Section 125 of the Criminal Procedure Code, or the secular law, ruling that this applies to all women irrespective of religion. And then, just a couple of weeks ago, the Karnataka High Court questioned a woman who had asked for over rupees 6 lakhs per month as maintenance from her ex-husband. The court advised the woman to provide a more reasonable account of her expenses if she wanted the court to consider her application further. So what exactly is a divorced person entitled to as maintenance, spousal and child support if children are involved under the divorce laws in the country? How is this amount calculated? Why do so many women have to approach the higher courts for maintenance? Does the principle of being able to live in the same position as prior to the divorce apply? And does there need to be a fairer, more sensitive system for all involved? We discuss these questions and more with Mihira Sood, a lawyer at the Supreme Court of India and a visiting professor at the National Law University, Delhi. Welcome to the Hindus in Focus podcast, ma'am.
Happy to be here. Thank you for having me.
Could we start with you giving us an overview of maintenance, spousal and child support under the different personal laws in India?
Okay, so basically, one is, of course, you have the maintenance provision under the Criminal Procedure Code, right? That is a law that applies to all persons. It can apply to all persons, even as has recently been held under Muslim personal law, where there was for some time some debate about whether or not it was specifically excluded. Now, the basic requirements for the law of maintenance to apply, and it's important to know that under secular law, maintenance is not something that is limited to husband and wife. I mean, there is matrimonial maintenance also, but there is also maintenance for children. There is maintenance for any family member can make a claim for maintenance. When it comes to matrimonial maintenance, you have to, of course, firstly prove the relationship between husband and wife. However, we do not have a system where there is an automatic 50-50. The wife has to prove that she's unable to maintain herself, that her husband has sufficient means, and then the amount is going to be calculated based on his earning, her requirement, and there's a lot of judicial discretion for the courts to look at what are the various sources of income that she may have or that she may tap into, and what are the burdens on each of them. And that also has a role to play. So it's not like once you split up, all your assets are divided 50%. That doesn't happen. You need to kind of prove your need for maintenance. Under Muslim law, we know the recent judgment also basically provided that even there, the secular law can apply. It is not that the secular law does not apply in cases of Muslim law. We'll discuss that particular issue more in detail subsequently. And then you have also the Parsi law and Christian law. And I mean, in these situations as well, it is considered, I mean, the Indian Divorce Act, which applies to Christians, is very similar to the Hindu law, but it differs only in the respect that maintenance during the pendency of the dispute can be claimed only by the wife and not by the husband. She can apply for maintenance in any civil court, and it doesn't have to be in a criminal court. And under Parsi law as well, the same considerations are applied in granting maintenance. The considerations are broadly the same regardless of the personal law. One looks at the need, the expenses, the necessary expenses, and what would be sort of the best way to accommodate all of those concerns.
Moving on to what you mentioned a little earlier, the recent Supreme Court judgment that said Muslim women can apply for maintenance under the secular law, irrespective of there being a separate Muslim law in this regard. Could you explain this judgment to us a little bit and why it is significant?
You had, I mean, to go back in history a little bit, you had the Shah Bano case of 1986. And in that case, 1985, in that case, the Madhya Pradesh High Court had ordered a monthly payment of 179 rupees for Shah Bano from her husband. They had been married for 43 years and had 5 children together. So I mean, these are the circumstances, and these are important circumstances in looking at a claim for maintenance as well. You know, how long has a person been married? Because that also presumably impacts how long, if a person has been out of the workforce, how easy or difficult is it for them to get back into the workforce? How many children are there? How much sacrifice has been made by the woman in contributing to the family and household? All of these things are considerations. And then her husband filed an appeal against this, saying that as per Muslim law, he was only required to pay her during Muslim law has a concept called the iddat period. So basically, the 3 months following a separation is called the iddat period. And the rationale for that is to prove that she is not pregnant. So in those 3 months after divorce, she's not permitted to remarry. And in that time, maintenance is required to be paid. But once she is permitted to remarry under Muslim personal law, the husband was no longer required to pay maintenance. So the Chief Justice was part of the bench that accepted her plea and looked at her circumstances and said that it would be unjust to limit her rights in this manner, and that secular law has to apply to all citizens. And then we know that there was a lot of political pressure, and the government passed a new law with the intention of nullifying this judgment. And this new law was called the Muslim Women Protection of Rights on Divorce Act. Now, according to this law, it provided for a reasonable and fair maintenance within the iddat period for a wife and for children up to the age of 2 years. Under secular law, please note that maintenance can be for life for the wife and for children until the age of majority. This legislation also provided that if a woman was unable to maintain herself or her children after this period, the responsibility would not be on the husband, but on any relatives who stood to inherit from her. It would be their job to provide maintenance. And failing that, the Waqf board would provide maintenance. Now, this was challenged by in subsequent cases, and the court held that this places women in an inferior position because this is a very illusory remedy, to rely on unnamed relatives or on, perennially cash strapped Waqf board. We know that the woman is unlikely to receive any kind of benefit here. So the court basically had two options before it. They said if a Muslim woman is placed in an inferior situation under personal law, then this law would be unconstitutional, inferior as regards to secular law. However, the court said we can save your law if it is interpreted to avoid such an outcome. That is actually what happened in the court during that case, that it was agreed that the law would be interpreted to avoid this outcome that places a woman in an inferior situation. So it was interpreted that reasonable and fair maintenance requires that the husband has to contemplate her future needs also and has to make preparatory arrangements in advance to meet those needs within the iddat period. But it does not require that the actual payment has to happen within the iddat period only. So it was a kind of creative interpretation done in order to save the law, which the government agreed to, that the maintenance that the law contemplated would include keeping in mind future needs as well. So the in the recent case, and this has been the position now since the decision of Daniel Latifi. But in the recent case, it was kind of a reiteration of this principle. And it said that if a husband opposes any maintenance claim under secular law, it can only be if he has already made adequate payments and the wife is capable of maintaining herself, because the court very clearly held personal law is only in addition to secular law. It is not in derogation of it, and it cannot replace it entirely to the disadvantage of the woman. And the court also, I mean, looked at some basic principles of judicial interpretation, that what would be the intended outcome of legislation and the social realities that are faced by women. And that was, I think, what made the judgment so progressive.
Talk to us a little bit about what you mentioned earlier, that this India doesn't have a 50-50 scenario where assets are split, but all of these factors, such as how many years you have been married, how many kids you have, how much the woman has sacrificed to put perhaps her career on hold in order to run the household. What are the other factors, and what goes into finally the maintenance amount being decided? And is this calculated as a percentage of the husband's salary? Is that how it's normally done?
There is no real formula, to be honest. This is all on a case by case basis. And we do find that sometimes judges are also guided by their own personal perceptions of what is a reasonable amount, which may not always be in accordance with the social reality of the couple before them. For example, we saw the recent case, and we'll obviously discuss that in greater detail in Karnataka. But you have couples where they're earning a very very high amount. The income, the family income has been very high, but what judges consider as a reasonable amount to live a reasonable life is not something that is in keeping with what the woman may need to continue living life as per the standard she was previously accustomed. And broadly speaking, that is a sort of vague standard that is kept in mind. As far as possible, can you live in the same manner to which you were previously accustomed? And that's something that really requires the court to look at your very unique individual circumstances. And then, of course, the court looks at your, what are your requirements? Are there, how many dependents does each person have, the husband or the wife? What are the requirements to look after those dependents? That's a big one, particularly in a country like India, where we do have a very tight knit, large families, where the responsibility, the cost of looking after people, whether including whether it's siblings or um, elderly people in the family, these are borne by the family, and within the household itself. So there is that, looking at what are the demands on your income, and of course children, their education. Future planning for education is something that isn't always looked at as much as it should be, and it's important, particularly if, again, and this is coming back to different circumstances, different families, but if you are in a situation where it would be considered reasonable for your child to be maybe studying abroad, that kind of future planning is not something that the courts look at. The courts tend to look at what is a bare minimum. That is slowly changing. In all of these things, when we are talking about what is the standard that the courts are applying, the courts have traditionally looked at what is the bare minimum you need. And that is what is changing a little bit in some areas and needs to change more, because a person doesn't survive on the bare minimum alone, nor is it fair or just to expect a person to survive on the bare minimum alone when their former spouse, who they've been married to maybe for a very long time, is earning very very handsomely. So that's something that does need to be looked at. We need to, I think the judges also need to be sensitized to move their standards beyond the bare minimum and appreciate that different families may be accustomed to living by a standard that may seem extravagant to a judge, but that's their reality.
Speaking about the extravagance, as you mentioned earlier, the Karnataka High Court had recently told a woman who was seeking spousal support to the extent of 6 lakhs per month or a little bit more, that she needed to be more reasonable in her demands. Now, need a do we need it? Do you think there's a need for a legislation that works this out? Why should it be on a case to case discretionary basis? Is that something that is required?
I think there's always room for discretion, but there needs to be a rule, a basic rule on which that discretion is applied. That I think that the rule cannot be so for any formula cannot be so rigid that there is no room for discretion, there is no room to appreciate unique circumstances. But that does not mean that there shouldn't be a basic formula at all. So if you ask me personally, I think by and large the court should the court should certainly be looking at the education and opportunity, um, employment opportunities available to the woman at that stage. Because very often we just look at, oh, you went to such and such college, you have such and such degree, you can easily get a job. Whereas we know that if somebody has been out of the workforce for 10, 12, 15 years, they cannot that easily get a job. And it's, very, very difficult for them to run their household and suddenly change their entire life in this way. So, what is the employability, current employability? One is that. Um, and that also takes into account what are her other responsibilities. If she has a lot of like family care responsibilities, perhaps she cannot take a job that she may even be eligible for. So that also needs to be looked at. It's not as if that just because somebody is divorced now they should be forced into a job that they find difficult to do because of their care responsibilities. It shouldn't be a burden. One is that. So what are the possibilities acceptable to her for employment? um, of course the length of the marriage and all of that plays a role here, because again, if you've been married for 1 year, then it is understandably difficult for the court to accept that you're lost a huge amount of opportunity here. If you've been married for 10 years, it makes a difference even if you don't have children, because their care responsibilities extend beyond children. There could be, very often women are the ones tasked with caring for their in-laws, and generally running the house, which can be a very time consuming job as well. So it's not just about children. These kind of basic points need judges need sensitization. Very often we look at, you're well educated, you don't have any children, go out and get a job, but it's not that simple. And of course, what is the earning? What is the husband earning? Um, and what is the lifestyle that they normally, what are their normal monthly expenses? What do they normally spend on together? What kind of lifestyle do they live? And to what extent is it possible to replicate that to provide least disruption to both parties? Um, the other thing that courts need to be very sensitive and wise to is that during matrimonial proceedings, very often we see a transfer of assets. Husband will transfer assets out of his name to the name of parents or siblings, or even close friends, on the agreement that it will be retransferred at later, in order to show that he has very little in his name. So the court needs to be wise to this. I think women also need to be very aware of what the family financial situation is, so that she can provide a clear picture. And courts need to also be on the lookout for unusual transactions during or in the run up to matrimonial proceedings, in order to try and evade responsibility. And that's the thing, it should be seen as a responsibility, not some kind of charity. or burden on the husband, but a responsibility. Because the fact of the matter is that when you have married somebody, um, you know, the traditionally, and is applies to, most of the marriages in India, it is with the expectation of certain traditional responsibilities, particularly caregiving and household management. So then there is a responsibility then on the husband as well, that if the wife is going to do these things, sometimes in addition to her regular job, then it is my responsibility to provide. So, I think maintenance needs to be recast as a responsibility of the husband, until we see some real change in the way marital relationships are conducted.
That was very clear. Thank you. That's something I wanted to uh, ask you about as well. The fact that in many cases the husband is able to go out and earn and maybe have a great career is because of the fact that his wife is at home taking care of the house and looking after the children. Correct.
Yeah.
So in the sense that she is has an equally responsible job as well. It's just not paid employment. So So moving on a little bit, Mihira, could you talk to us about, has there been a situation, we have almost exclusively spoken about the fact that the husband has to pay maintenance for the wife and the children. Has there been a reversal like that? Have there been cases where the husband can claim or is allowed to claim
So
maintenance?
technically, I mean, theoretically, it is possible, but I am not sure if there have been any such cases in India where the claim has succeeded. Though theoretically it's possible under the Hindu Marriage Act, either spouse can apply for maintenance. As I said earlier, that's one of the differences between the Hindu Marriage Act and the Indian Divorce Act, which applies to Christians. But I'm not aware of any successful claim for maintenance from made by the husband.
Let's move on to another issue, that of child custody. How do the courts usually rule on this? Is this changing? And does this affect the amount of maintenance or support payments that the wife or the husband receive?
So child custody is one of those areas where there's a slight change. I think earlier it was a very difficult situation for women because women were caught in a bit of a double bind. If women were working, and even today the argument is still attempted that if women are working, then it will be argued that she's not home, she's not looking after the child. And if women are not working, then it's argued that she doesn't have the financial resources to look after the child. So both these arguments are used frequently against women. But and the reverse of course doesn't apply to men, because men are working and men have the financial resources, but then when they're not home to look after the child, the response which courts have many times accepted is, his parents are there. So some woman, basically it always falls on some woman, whether it is the mother, whether it is the husband's mother, whether it is, there is always some woman there to look after the child, and therefore it doesn't even necessarily need to be the parent. That's the argument made, and has very often been accepted. I think what's changing now in some areas at least, and it's a very welcome if nascent change. You have a lot more women in a situation where if they are separated or divorced, their parents are happy to live with them or have the daughter live with them. So earlier it would be a situation where you can't go back to your parents' house, and you need that support if you're working and you have a child. But that situation is changing. I think there's a lot more support coming from parents of women that is enabling them to make a custody claim, whether working or not working, and also giving them a little bit more financial support. I think the inheritance laws in the reform in favor of women that came about in the early 2000s also had a role to play in that, because the more women are financially supported outside of their husbands and their matrimonial relationships, the more confident they feel also. So that has changed. Generally, yes, the courts would, if various these things are in place, prefer to give custody to the mother. But there are certain situations, I mean, through experience, one has seen certain types of situations where this tends to flip. If the mother wants to, for example, live abroad, we then find that very often this is something that courts are reluctant to permit. And then there's a lot of sort of anxiety that comes in about raising children with Indian values, even though that can be done anywhere in the world. So a lot of times in those situations, courts will, we have seen, uh, insist that the child stay with the father because of the location more than anything else, not the best interest of the child. The guiding factor always has to be the best interest of the child. And that's the goal, that's the standard for deciding any custody dispute. Um, and best interest of the child certainly includes, stability. I think when it comes to a gender also plays a role. When it comes to a girl child, courts will almost always side with the mother. But when it comes to a male child, the standards are a lot more variable. Unfortunately, we also see a lot of cases where, very irrelevant factors are taken into consideration for what constitutes a good parent, particularly a good mother. We have, one standard tactics in custody disputes is, where the husband's, lawyer they trawl through, say, old photographs and social media of the wife, and any one photo where, say, she's holding a glass of wine in her hand, or she's, with a male friend. These things are then put together to create an image designed to make the judge uncomfortable and say, no, no, this child is better off with the father. So we really need to get rid of these archaic mindsets, and also be wary of how easy it is to um, create a very exaggerated picture, based on these small things. So that also needs to be looked at. And there needs to be an understanding that women have their own lives. A good mother is not just somebody who is 24/7, you know only parenting her child. She can take a break sometimes, as long as her child is well looked after by another trusted person. That kind of leeway is not really given in our society. And again, it's something that's very personal, depends on the judge, um, and generally how liberal, how open minded they are. But these are things that can really interfere with a woman's custody claim.
Do you think it would be healthy to have a law, or is it should there be a requirement for child custody to be shared equally? I know it's not generally the case in India, but is it something that should be looked at in terms of the child having equal access to both parents, even if they're not living together? Of course, unless it's a situation where there was abuse or some other problem like that.
It's, to be honest, it's very difficult to implement, and it would really, I mean, the court would really have to look at whether or not it's interfering with the stability of the child. Because I mean, equal access means literally like 3.5 days a week kind of thing with one parent, or 1 week with one parent and then 1 week with another parent. It can be destabilizing. It also depends a lot on, do the parents live nearby? Is it, some distance away? And then, even in terms of custody, there's different aspects. One part of it may be, just spending time, but there's also decision making and basic control. Like, for example, things like, where the child should go to school, or, which doctor should I consult for the child, or uh, you know should the child travel to this place on a basic day-to-day decision making. Everything it would be quite cumbersome for decisional custody to be shared equally, for example, particularly if the couple doesn't see eye to eye at all. And so I think even in these situations also, I think the court would be more likely to look at a generous visitation agreement rather than joint custody.
Thank you so much for speaking to us today, Mihira.
Absolutely. My pleasure.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.